Hey, everybody. Good afternoon if you're with us from the East Coast, and otherwise, if you're tuning in elsewhere, glad you're here. We are at the end of May. Tough to believe it that this will be our last broadcast. Hopeful that all of you had a terrific holiday weekend. And for those of you who were remembering loved ones or others in your community who served, I'm hopeful you were able to honor them. We have a great program here this afternoon that I want to walk you all through, please. After I give you just a few moments of my time, we'll be hearing next from Mark Krawick, who is with us from our Buffalo office, who is a senior counsel, and who will be focusing on artificial intelligence in regulated industries. Mark is on the program for the first time, joined our firm roughly within the last year, and we're delighted that he's now on the program for his first of what we hope will be a number of presentations. DJ Nugent is back with us from our Syracuse office, and DJ, who works on a variety of matters relating to employee compensation, is with us to tell us about recent developments touching on Internal Revenue Code, sections 409A and 457F. Victoria Okrzycki is with us also in Buffalo, and Victoria has taken the time to develop a piece concerning manufacturing industry risks around cybersecurity that she's going to walk us through here on the program. And Brendan Goodwine, who is a member of our intellectual property group, is with us today from Rochester. Normally, Brendan sits in our Syracuse office, and we're glad that he is with us today. And he will be focusing on patent infringement updates relating to design, and also design patent law matters. And this is all coming out of the Federal Circuit. And so with that, let me then move to introduce our first of four speakers. And we're glad that, again, we have Mark with us. Mark is a senior counsel based in our Buffalo office. Mark has had an interesting and varied career and joined us after having been working in the healthcare reimbursement industry. And there's a lot of background that Mark has that relates to both health and cyber and data privacy matters. Mark and I have had the opportunity to work on a few matters already since Mark joined. And Mark was part of the group of attorneys that traveled the state earlier this year to present on the changing nature of artificial intelligence. It's rapidly advancing, and is here to focus on an area concerning regulated industries that he remains on top of and otherwise available to talk about with any of you. So, Mark, why don't you please give the group an introduction to some of the themes and areas that you've been tracking closely. We look forward to learning from you.
Sure. Thanks. Thanks for the introduction, Gabe. One thing I'll add, in addition to having worked for about 7.5 years in the health insurance world, before that, I worked at a bank in both banking and insurance on the agency producer side, and also a little bit in the brokerage, the financial services brokerage world. So, as you'll see with the presentation here, I think a lot of the themes are going to be based on those types of industries, though I do think the principles will apply fairly generally to any type of regulated industry. Can we skip ahead on the slides? Thank you. So I will cover a very brief overview of some existing guidance when it comes to use of AI in regulated industries. I'll talk a little bit about some use cases. I'll talk a little bit about some existing laws and regulations, and a lot of this stuff is very recent and it's evolving very quickly. And then I'll talk about a couple examples of where things go wrong, and at least to me, I think those are areas we can learn from. So again, industry-specific examples, but the principles may apply more broadly. Can we move ahead? So in terms of guidance on AI. There's a lot out there in the regulated industries world. The White House has two publications. There was an AI Bill of Rights that was published in October of 2022. That wasn't really binding. It was just sort of a directional set of principles, guidance that federal agencies and businesses regulated by federal agencies should start thinking about. That was supplemented with an executive order in October of 2023, and that had some more specific and meaningful takeaways, a couple of which I'll talk about later in the presentation. NIST is one of the agencies that was impacted by the 2023 executive order. If you're in the healthcare world and you deal with HIPAA privacy issues, security issues, a lot of what you're dealing with comes from NIST standards. For those who don't know, NIST is the National Institute on Standards and Technology. And as their name suggests, they develop, promulgate publications, standards in that space. One of the things NIST was charged with in the October of 2023 executive order was developing standards for software development using generative AI. And those standards, at least the initial draft, were just released about 4 weeks ago. We're going to be working on an information memo that talks about them in a little more detail. But like I said earlier, this stuff is really evolving quickly, and sort of across all different agencies, at least the federal government. The FTC has issued a statement. It was an interagency statement with the CFPB, with the DOJ, and the EEOC. I think that one was from April of 23. The reason I mention it is I'll talk about some FTC enforcement at the end here. But the FTC's statement references existing laws, and I think that's one of the themes you'll see in regulated industries, is that a lot of the guidance when it comes to how you might develop or deploy AI tools is based on existing laws, regulations, principles, and in the FTC's case, it has to do with unfair, deceptive trade practices, and some of the enforcement talks about or illustrates how use of AI tools, or maybe improper use of AI tools, can run afoul of those principles. The last one I'll talk about on this slide here, the NAIC, that's the National Association of Insurance Commissioners. That is a group that publishes model laws, model regulations for state insurance regulators. And they had again, sort of a set of principles that were published back in 2020. And then more recently, the NAIC published a model AI regulation, which this was in December of 2023. I'll talk about that in a little more detail in a minute. Can we move to the next slide? So in terms of AI uses, I guess one of the things I draw attention to, I think in the news media, you often hear about generative AI. You hear about ChatGPT a lot, especially sort of second half of last year, you would see these stories about all the things it can do and how amazing it is. And a lot of times you'd see stories about how it gets kind of obvious things wrong. But that's not the only use of AI in a regulated industry, and I think it's probably not even the primary one. A lot of the uses that you're seeing, at least right now, tend to be tools that sit on top of other data sources that a business might have, and they help you either become more efficient, better, or extend your reach in terms of using the data you have and performing the tasks you'd otherwise perform without those tools. So these examples, they're based primarily on the financial services industry, but just like in the insurance world, there are tools that can sort of harmonize your customer relationship management software, your claim software, and that can help you process claims. So for example, there may be a tool that can analyze images and triage how an auto accident claim is processed. There are tools that can help identify or analyze, social networks and identify potential fraud. In the customer service world, I think in general, people don't tend to be thrilled with the customer service they have in the financial services industry, and you spend a lot of time on the phone, a lot of time on hold. But these tools can really help the call center agents improve the experience by feeding them information about, this is what your last call was about, or this is when it was, or if you're talking about a claim, serving that stuff up to the call center agents and helping them become more efficient and more effective in providing that customer service. One of the things I'll mention just before we move on from this slide, the NAIC did some surveys of insurers over the last couple of years, one of auto insurers, one of property and casualty insurers. And they asked a lot of questions, several hundred questions around how are you using these tools? How do you expect to use these tools? What kind of risks have you identified? What are your concerns? In terms of what tools are being used, there was, to me, a really interesting distinction when it comes to marketing and underwriting. So 97% of the tools that were being used in marketing were third-party tools, basically developed by a vendor. And those are primarily, Facebook, Instagram, social networks for serving targeted ads. Conversely, about 86% of the underwriting and pricing tools were developed in-house. And so, I think there's a little bit of a mix of buying tools to sort of maintain the status quo within the industry, and then developing tools that might give you a competitive advantage. And, whether you're buying a tool, building a tool, or maybe customizing something that a third party has built, a lot of the principles that I'll talk about in a minute here, I think are going to apply and are things you should be aware of. Can we move to the next slide? We can go to one after this. So I mentioned the AI Bill of Rights, and this was from October of 22. It preceded the executive order in 23. I highlight the first 3 points here because I think in any regulatory scheme, these three principles are going to be present. And as we're seeing, more specific regulations develop, I'll say particularly the NAIC model regulation, ensuring that systems are safe, understanding how they were developed. Again, whether it's proprietary development in-house or you're buying it from a third party, you're going to be expected to understand how the tool works, to test it, to be able to explain to your regulators what the expected outcomes are. And just saying that, well, we didn't create it, we bought it from a third party. I don't think there's any regulator that's going to be satisfied with that. Discrimination is another huge theme that you'll see in the regulatory guidance or regulations, laws when it comes to use of AI in a regulated industry. A lot of this has to do with the quality and the accuracy of the data that goes into these tools. Again, the high level concern is you build something based on bad data, and the AI tool starts to expand on that, and it creates a result that maybe a human would have recognized or caught earlier. So one of the things you'll see when it comes to regulatory proposals is that you may need to test your algorithm, or you may need to have your vendor supply you with data that satisfies your regulator, that the tools you're using are not unfairly discriminatory. And then data privacy, I think that's a fairly well-known concern throughout any industry. But just one, and it's maybe obvious, one thing to keep in mind when it comes to data privacy, going back to the generative AI tools, people can take documents, they can take spreadsheets, they can put that data into ChatGPT and ask it to help with it, analyze it, create something based on it. That data does not stay confidential or proprietary, and the creators of these generative AI tools use that data to test and train and build their models. So just even at a very high level, without getting into industry specific privacy, confidentiality requirements, just be aware of where your data is going and think about, potential controls to limit, it going outside the organization to a third party that may not use it the way you expect. Can we move to the next one? I think we can skip how am I doing on time?
You have a minute or two more.
Okay, can we go to the example of Louisiana, which is toward the end? This is an example of just when things go wrong. So Louisiana insurance regulator issued this bulletin in January 23, and it said, policyholders have a right to be treated fairly, free from unfair, deceptive acts and practices. Again, existing law, very widely applied. Every insurance regulator has some version of this throughout, all 50 states. Going to the next slide. This came out of an example of property and casualty customers in this West Feliciana Parish, Louisiana, getting denials or huge rate increases. This is a very small parish, 15,000 people live there. Roughly, Buffalo is about 200 times as dense as this place. People thought it was a safe place, didn't understand why they were getting these denials and rate increases. And so they did a little digging, brought the regulators in, and the regulators said, oh, it's the crime score. You've got an F rating based on this FBI crime score database we use to price insurance. And within like 5 minutes, the locals explained what the problem was. And the problem is that on the satellite view, the top left corner, that's a little brownish, that is the largest maximum security prison in the United States. There's 5,000 inmates in it, which is the 15,000 residents of this county include those 5,000 inmates. So you can probably see where this is going. Turns out that within that prison, there's a lot of crimes that were being committed. Those crimes are being adjudicated within the county. And when those were added to everything happening outside the prison walls, you ended up with this really bad crime score. When they were taken out, the crime score would have been an A. And, so the Louisiana insurance regulator published this bulletin. It took 1 week from when they started the investigation till when they actually issued the publication, which is, in my view, light speed. But it's just one of those examples of, not just plugging numbers into the algorithm or not just deploying the algorithm and letting it run. You need to understand what goes into it. You need to understand how it works. You need to understand what the expected outcome is. And you probably need to test it and audit it every once in a while to make sure, it's working as expected. I don't think we've got time for the last two, so I'll leave it there unless there are questions, comments.
Mark, that's great. And you're absolutely correct that there are ways in which this all needs to be tested and thought through. And that anecdote concerning the Louisiana parish really brings it home. So we appreciate you taking the time to present on these issues. We hope you come back to the program, and thank you so much for taking the time today. Let me move then to our next presenter, who's DJ Nugent. DJ has been on the program a number of times, of course, and DJ is part of our team that focuses on employee benefits. And DJ wants to use developments in the world of sports as a means of bringing you closer to IRC updates affecting 409A and 457F. DJ, looking to understand that connection a little bit better. As a sports fan, I'm listening closely and look forward to learning. Thank you.
Thanks, Gabe. So just to start, certainly no new developments with the actual pieces of legislation under Code Section 409A and Code Section 457F, but just for everybody's information on the call, this is the 50th anniversary of the Employee Retirement Income Security Act of 1974, more commonly referred to as ERISA, and our employee benefits and executive compensation group has some programming planned for that 50th anniversary where we're looking at some common areas under ERISA that employers find themselves encountering issues. As part of that process, we're also looking at other areas, particularly in the Internal Revenue Code, where employers find themselves in some common tax traps with either their employee benefit plans or their arrangements with executives or other employees in the severance world. So with that being said, not that it's necessarily any new piece of law, but just to provide a refresher on those two Internal Revenue Code developments, I wanted to look at two things that have happened in the world of sports that have been widely reported that may provide some form of entertaining illustration on how these Internal Revenue Code provisions act and interact with each other, and the ways that employers can avoid adverse consequences under both of those. So if you can move to the next slide, please, Kathy. The two developments that have been reported in the past several years that I'm going to use purely for anecdotal purposes are the following. The first is the Shohei Ohtani contract that was signed in 2023 with the Los Angeles Dodgers. And the second is there's been several high-profile college football coach contract buyouts reported in the news. And I'll provide some more information from a very high level, but just to put it out there, I'm only reporting on what was publicly available in the news. I don't have any insider information or inside baseball, no pun intended there. So I'm certainly not reporting on any actual specific details with respect to these arrangements. For Mr. Ohtani's arrangement, he signed a 10-year, $700 million contract with the Los Angeles Dodgers. Essentially, he's agreed to play for the Dodgers for a 10-year period of time. What caught my attention as an executive compensation attorney is that during his 10 years of playing, he's only going to receive $2 million per year, thereby deferring $68 million per year in salary until after that 10-year contract period is up. After that 10-year contract period is up, it's been reported that he's going to receive $680 million in deferred compensation payable between 2034 and 2043 without interest. So we're going to use this situation to discuss the non-qualified deferred compensation issues that come up here, and that certainly can come up in more common executive arrangements where $680 million aren't involved, but the principles are the same. The second general set of situations that I'm going to use just to illustrate some issues are that in the news over the past several years, there's been a variety of reports of college football coaches who negotiate their contracts with the universities to include a buyout clause. And essentially what that buyout clause says is, I sign a 5-year contract with the university. If you terminate me without cause, which would generally be, we want to move in a different coaching direction. We don't think the coach is performing the way that we want him to, or we want this college football coach, we want to move in a different direction with the university. The contract hasn't expired. Therefore, the college or the university has to pay the football coach a buyout payment. Now, there is a flip side of the coin that I'm not addressing at all, where football coaches, if they leave earlier than the end of their contract, they may owe a buyout to the college themselves. Different set of issues there. Why I'm using this is really akin to a severance payment, where a rank and file employee may be terminated without cause and is provided with a set of payments as a result of that termination without cause. Now, the college football coaches, the numbers that are involved are eye-catching, and that's why I wanted to use them for purposes of this exercise. We've seen 76 million, 21.5 million, and 16.9 million, among other very large numbers. So just something interesting to apply a more general severance arrangement to, just with a kind of an up-to-date example that we can use to provide some insight into this. Next slide, please, Kathy. So I'm going to start. The first code provision that I'm going to talk about is Internal Revenue Code section 409A. And I'm going to use the Shohei Ohtani example to illustrate the issues that can come up under this Internal Revenue Code section. To begin, Code section 409A applies to all forms of what's defined as deferred compensation unless exempted. Generally, deferred compensation is defined as any compensation earned or in which you have a legally binding right in 1 year that's paid in a later year. So if I have a legally binding right to a payment in 2024, and that payment is set to be made in 2025, that would generally fall within the definition of deferred compensation, and we would need to consider the Code section 409A and potentially Code section 457F implications of those arrangements. Code section 409A applies to both for-profit and tax-exempt entity. So it's a pretty broad scoped statute. These arrangements are not what we would think of. Sometimes when I describe what deferred compensation is, people think, well, that seems a lot like an employer matching contribution in a 401k plan or a 403b plan. Those types of retirement plans are exempted from 409A. In fact, what we're talking about with these types of deferred compensation arrangements are that these arrangements cannot be funded. Essentially, money cannot be set aside for employees in these types of arrangements that can't be assigned to the company's general creditors. Essentially, the company's general creditors will still need to be able to get at any funds that are set aside for these employees. So that's a slightly different context than in the 401k and 403b. In the 409A world, it's important to either find an exemption from 409A or know what the employer and the employee need to do to comply with the requirements of Code Section 409A. Why it's important either to find an exemption or to comply with the requirements is that a violation of Code Section 409A results in a 20% excise tax on the employee plus an interest penalty. And employers also have an obligation to correctly report and withhold tax payments, so that can be an issue for them as well. If there is a violation of 409A and an employee is not only paying, we could say that, the top tax rate of 40% plus an additional 20%, so they're at 60%, the employee may be looking to their employer to make them whole to some extent. So it's important that both employers and employees know about these rules. The first step in any 409A arrangement is to see, can we exempt this arrangement from 409A? So the broad categories of exemption from 409A are certain kinds of severance pay. I'm going to talk about that category in connection with the college football coach buyout arrangements. Stock options, if certain requirements are met, that wouldn't apply to Mr. Otani's example because it's just straight deferred compensation, not payable in a stock option. The severance pay example is also not applicable to Mr. Otani because the payment is not triggered upon his termination of employment. He's actually getting this as part of his general compensation to work. It's just payable after he leaves employment in theory. I also talked about the other exemption for qualified retirement plans and other eligible deferred compensation plans. So that grabs a lot of the more standard retirement plans, won't be exempt, it won't be subject to the 409A requirements. And then most commonly used to exempt these types of non-qualified deferred compensation arrangements from Code Section 409A is something that's referred to as the short-term deferral exception. And that could be what Mr. Otani's arrangement could have been structured to fall into. The dollar figure for him probably is why the Dodgers did not enter into that type of arrangement. What a short-term deferral exemption says is that 409A does not apply if all of the payments due to the employee are made by March 15th of the year following the year in which any substantial risk of forfeiture lapses. Therefore, if Mr. Otani worked for 10 years, excuse me one second. If Mr. Otani has to work for 10 years to receive the $680 million in deferred compensation, essentially that whole $680 million would need to be paid by March 15th of the year following that 10th year. That's obviously not the case here. They're going to pay the $680 million over another 10-year period. Therefore, this arrangement is not exempt from 409A, and the Dodgers and Mr. Otani would need to know what they need to do to comply with Code Section 409A. Next slide, please, Kathy. So to comply with 409A, essentially what needs to happen is the employer needs to be aware that there's 1 of 7 permitted trigger payment events. Generally, and this is the big clause, payments can't be accelerated, and once the time and form of payment is elected, it can't be changed except with limited exceptions. In the for-profit world, which 409A applies to, the benefit of it is if you comply with 409A, the deferred compensation is not includable in income, even if it becomes vested until the tax year in which the amounts are actually paid. Next slide, please, Kathy. I'm just going to go through this very quickly. I touched on what the college football coach buyout arrangements typically are. In the tax-exempt governmental world, there's an additional code section other than 409A that employers also need to be aware of, and that's Code Section 457F. What Code Section 457F says is that the present value of deferred compensation subject to 457F is included in the gross income of an employee when the employee has a legally binding right to the compensation, or if later, when the compensation is no longer subject to a substantial risk of forfeiture. Therefore, if you have deferred compensation that's subject to 457F, in contrast to a for-profit arrangement where you can have a vesting date occur and then payment be made later, and those payments are only includable in tax when the payment is made later, under 457F, if vesting occurs, then payment is going to be includable in the employee's income, even if not payable yet. The way to get around that result, which is an adverse result, because we're saying, okay, an employee needs to include a substantial amount of money in income, but that money isn't actually payable to the employee, is to fall within an exemption to 457F. There's several exemptions very similar to the 409A rules. One is the short-term deferral exemption that I just described, and the next is a bona fide severance pay plan. Next slide, please, Kathy. The bona fide severance pay plan exemption will typically cover most types of severance that employers enter into with their employees that are similar in concept to the coaching buyouts, just with lower dollar figures. What needs to be met to fall into this exemption is there needs to be an involuntary termination of employment or a good reason resignation by the employee, and that's a statutorily defined concept. The payment cannot exceed 2 times the employee's annualized compensation, and the payments must be made over a period not exceeding 2 years from the year of termination of employment. If you don't structure your severance arrangement and you're a tax exempt or governmental employer to fit the severance pay plan exception, it really is important to try to structure it to meet the short-term deferral exception, because if you don't meet either of those exceptions and you are making severance payments over a period of time spanning more than 2 taxable years, that those employees can potentially have that adverse tax consequence of including amounts in income, but not having the actual money to pay the tax yet. So I just provided a very high level overview of these very detailed concepts, just as a refresher and just with those items that had been reported in the news. But I'm certainly happy to answer questions in more detail if need be.
So DJ, thank you so much. Really useful to remind us all that ERISA is turning 50 and that there are these interesting nuances that as casual readers of the news we might not be thinking of, but that you have unpacked for us. Certainly a lot of fun to dive into these issues, and we hope that you come on back as you continue to as a group focus on ERISA so that we can learn more about its various branches. But let me now turn to our third speaker for the day, who is Victoria Okuzuski, and Victoria is with us from Buffalo. Victoria has been on the program a number of times previously. As I've mentioned in her previous presentations, Victoria is from New York City originally, has moved to Buffalo as a part of our cybersecurity and data privacy practice, has done a lot of interesting work at the intersection of cyber, data privacy, and a bit of health as well. I've had the pleasure of working with her directly. Victoria, I look forward to learning with you about cyber risks in the manufacturing industry. Please go ahead, the floor is yours.
Thanks for the introduction, Gabe. As Gabe mentioned, I'll be discussing the current cyber risks that the manufacturing industry faces. Next slide, please, Calvin. So within recent years, just like many other companies, manufacturers have had a heavy reliance on advanced technology. For example, big companies such as Walmart have began using AI to negotiate contracts with their suppliers. Specifically, they'll use a software that uses a text user interface to negotiate with potential suppliers. And with that leaves these companies susceptible to cyber attacks. And the manufacturing industry is an attractive or a popular target for threat actors who are looking to access large repository of sensitive information, intellectual property, and customer financial records. And interesting, IBM X-Force published a report indicating that for the 3rd year in a row, the manufacturing industry has been the top target for threat actors. The report noted that malware accounted for 45% of the attacks, with ransomware accounting for approximately 17% of the attacks. Next slide, please. So these are some typical cybersecurity and data privacy concerns for the manufacturing industry. Cyber attacks can have detrimental consequences for many manufacturers, which can include supply chain disruptions, lost profits, loss of IP, and also reputational damage. And as I mentioned earlier, the specific concerns that the manufacturing industry faces are ransomware, phishing attacks, and supply chain attacks. So I'll just discuss each in turn for some knowledge. So ransomware is a type of malware that will block a data owner's access to its data unless a significant amount of money is paid to the threat actor or the person who deployed the malware in the network. And after ransomware is deployed, many organizations will have to remove the infected computer or systems from its network, which can be very time-consuming, disruptive, and costly. Next, phishing attacks occur when attackers will leverage text messaging, emails, or other forms of electronic communications to trick users into clicking on malicious links or divulging sensitive information. I'm sure with the amount of phishing attacks that occur daily, you guys all probably have heard of them at some point. And often when clicking on these malicious links or divulging sensitive information, the attackers will be able to obtain login credentials for company accounts and then perpetuate fraud, which can include stealing financial information from customers, pretty much shutting down a supply chain, things of that nature. And the supply chain, which is one of the most vulnerable aspects of a manufacturer's business, specifically, supply chains allow companies to create and deliver products, materials, and utilizing databases for automation to coordinate with business partners and vendors. There are 3 types of supply chain disruptions, which include software supply chain attacks, which basically is when attackers will compromise only one application or a piece of software to disrupt the entire supply chain. And generally, the attackers will target application source codes and deliver malicious code to a trusted app or software system. Firmware supply chain attacks occur when an attacker will insert malware into a computer's boot record, which can then be activated in minutes. So after the targeted computer will boot up or start, the malware is executed and the threat actor will gain entry into the network. These types of attacks are really quick, can be really damaging, and most often are undetectable until something goes wrong. Lastly, hardware supply chain attacks. So for these types of attacks depend on the physical devices. So for these, attackers may target devices that are critical to the manufacturing process, leading to a lengthy production delays and reputational harm. Next slide, please. So what manufacturers can do to protect themselves? So we always recommend to our clients to mitigate the possibility of a data breach to implement a comprehensive data protection and security program. And this could include implementing data security measures such as encrypting your data, whether it's at rest or in transit, using network firewalls, system audits, multi-factor authentication, access controls, and routine system patches and updates. Also, it's important to train your employees and educate them on these security risks and the possibilities of what could go wrong, and how to best protect the company itself. Also, just implementing policies and procedures such as an information security policy, record retention policies, incident response plans, and business continuity plans. So with that, for example, like a record retention policy, you'll only hold on to a piece of data for a certain amount of time, and then you'll destroy it within your system. For incident response plans, in the event something does go wrong, you have a set in stone policy that will list out all of the steps that you will take in order to eradicate the breach. Additionally, it's, as Mark mentioned earlier, the National Institute of Standards and Technology, also known as NIST, provided guidance for the manufacturing industry on identifying, assessing, and responding to cybersecurity risks throughout their supply chain. So NIST specifically noted within that guidance that many supply chain risks are associated with the lack of visibility and understanding of the business's process, and really urges business to really focus on the security, resiliency, reliability, safety, and integrity of its quality of products and services. And also they urge these companies to consider the cybersecurity risks throughout the entire supply chain process. And lastly, if you are a manufacturer with a government contract, you should also seek to comply with the Department of Defense's cybersecurity maturity model certification. This program was designed to ensure that there are sound cybersecurity practices in place to protect sensitive, unclassified information and federal contract information that is shared with the Department of Defense, with its contractors and subcontractors. So that's all I have for today. If there are any questions, feel free to reach out to me or any other attorney part of this cyber group.
Terrific, Victoria. Thank you so much for this update. Obviously, important for everybody listening to be aware of the risks that cybersecurity and a failure to be vigilant represents for your organizations. And we have a team, Victoria, among its members that's available to support you. Let me now shift to our last speaker for the afternoon, who's Brendan Goodwine. And Brendan is a attorney with us, normally sitting in Buffalo, but today with us from Rochester. Brendan is actually a registered patent attorney. And I had the opportunity to chat with Brendan recently when we were all together for a meeting in Syracuse, and asked whether he had anything interesting to share with the audience for the webinar. And Brendan thought that the topic he's about to discuss with you would be right for this audience. As we know, intellectual property affects us all in small and larger ways. And we just thought this would be a program edition of general interest. So Brendan, really glad that you're with us. I look forward to learning along with the audience here.
Thanks, Gabe. So if we could just advance to the first slide. There are a couple of topics that I'm going to talk about. And just briefly, we're a full service IP one-stop shop for your patents, trademarks, copyrights, and trade secrets. And so, the two cases I'm going to talk about today apply to a broad range of activities. The first one has to do with Amazon's Apex program. Well, what is Amazon's Apex program? Apex stands for Amazon Patent Evaluation Express, and Amazon touts this as sort of a quote unquote game changer for small businesses. And it essentially allows marketplace sellers to target potential infringers of their utility patents and get infringing products taken down from Amazon. So if you're selling products on Amazon, or if you have a patent and your competitors are selling something on Amazon, this may be relevant to you. Next slide, please. So the way that the Apex program works, initially the patent owner will submit a request through Amazon identifying their patent and any infringing ASIN numbers. These are numbers that identify different products listed on Amazon's website. Amazon will then decide whether or not to grant the request. The patent owner will sign an agreement and pay, I think currently it's $4,000. And then at that point, the sellers will receive a notice and the option to participate. Notably, if they don't participate, then their listings will automatically be taken down eventually. If they do participate, then the parties get to submit there are different infringement arguments, and then a neutral patent evaluator will make a determination. Next slide, please. So, the benefits of this are that it is true, relatively inexpensive compared to district court litigation. And also, we're talking in the range of months. Amazon says at least, or they average about 30 days to make a determination once they get to the argument stage. So, it is relatively inexpensive and quick. However, you have to be registered with Amazon's brand registry. It only covers utility patents, US utility patents, and we'll talk, the second topic that I have today deals with design patents. And then also, you can't get damages or attorney's fees. So the only result is, the listing comes down from Amazon's website. That seller can no longer sell. Next slide, please. So there was this interesting case that came out at the beginning of May, and Lighting Defense Group has this patent, and they wanted SnapRays, who sells these outlet covers with USB ports, to take down their listing. So next slide, please. So Lighting Defense initiated an apex proceeding against SnapRays, and SnapRays in response sued Lighting Defense in Utah. What's interesting about this is Lighting Defense is incorporated in Delaware and headquartered in Arizona. Otherwise, they don't really have any contacts in Utah. So normally, Lighting Defense wouldn't be able to be sued in Utah. But because of, as I'll mention, they initiated this Amazon proceeding, the Federal Circuit ultimately decided that they purposefully directed extrajudicial patent enforcement activities at Snap Power, included in SnapRays, in Utah. So next slide, please. So instead of Lighting Defense Group being able to sue SnapRays in Arizona or Delaware, where they already have a presence, Lighting Group now has to defend a lawsuit in Utah. They have to hire local counsel, and they have to defend that lawsuit there. So this is an important consideration, and is now different because the Federal Circuit is saying participating in Amazon's program is enough to let that defendant take you into a different jurisdiction, wherever that seller might be. So that I thought was an interesting conclusion or outcome. Next slide, please. So the second topic that I have is another Federal Circuit case, but it deals with design patents. So design patents, unlike utility patents, are for the original and ornamental design of an article. So the way that it looks, as opposed to the way that it functions or is used. And next slide, please. Some examples really quickly of just very famous design patents: the Coca-Cola bottle, the Fender guitar, and obviously the little Lego man. So, lots of different types of things are covered by design patents. Next slide, please. In this recent case, which just came out last week, GM owned a design patent for the front fender that was used in the 2018 to 2020 Chevy Equinox. And LKQ they're a parts manufacturer. They wanted to make replacement parts without licensing this design patent. They didn't want to pay a license. So LKQ tried to invalidate this patent. Next slide, please. So what ended up happening was the LKQ was unsuccessful in invalidating this design patent. Not happy with that determination, they appealed it to the Federal Circuit. And initially, the Federal Circuit in a 3-judge panel agreed with them, citing this old 30-year-old test, the Rosen-Durling test. However, shortly after that, the Federal Circuit decided to take up this case as en banc, which means the entire court. And they overruled this test. So the key points here, essentially in the old test, you had to have, quote unquote, basically the same visual impression. So very narrow, it has to be essentially the same. And then it also has to be, any other references have to be very related or quote unquote, so related when determining obviousness. And the Federal Circuit said that this was just too rigid and doesn't keep with recent or more recent Supreme Court decisions. Next slide, please. So the Federal Circuit came out with this new rule, which essentially is a reimagining of, or a reinterpretation rather, of Supreme Court precedent. And they applied this analogous art requirement. And so any reference has to be part of the analogous art. There's no longer a basically the same requirement, and there's no longer a so related. Interestingly, the Federal Circuit said, we do not delineate the full and precise contours of the analogous art test for design patents. So this is still sort of an open question. But next slide, please. This is important for a couple of reasons, but that are highlighted here. Namely, it overrules, it's a change of a pretty big rule that has been around for about 30 years. It takes effect immediately and applies to both pending applications and design patents that are already issued. And it is likely to make it more difficult to design patents. And in the same vein, it is likely to make it easier to invalidate patents now, design patents. And there's this overarching concern with the differences between utility and design patents. Typically in utility patents, you can't combine references without, or different teachings without some technical effort. So now it's a lot easier. So yeah, those are the two cases that I had prepared today. Gabe, if you want to take it back.
Thank you so much, Brendan. Really interesting. I will be personally on guard about Utah. No offense to anybody who happens to be tuning in from Utah. I'm joking, of course, but you know, the whole notion of being hailed into a jurisdiction you're not planning on is important to be aware of for anyone navigating that forum. And of course, the change in patent standards after 30 years is worth our time as well. So let me move briskly, because I know that we are over time. The workforce panels continue, one on Long Island on June 6th, one in Rochester on June 4th, New York City, June 11th, and Westchester, May 30th. I will be personally speaking both in Westchester and New York City. I look forward to seeing some of you in person there. And our next program will be in June. You'll be hearing from Kristen Smith. If you do wish to speak with any of the attorneys who presented today, you can reach out to them by email and I'm confident they'll be in touch with you. You can always, of course, reach out to me. Wishing you all a terrific end to this month of May and looking forward to being back with you in June when we'll have all sorts of things to discuss, including the end of New York State's legislative session and other updates. In the meanwhile, wishing you a great afternoon.